This is Alfie. Hi Alfie. Alfie thinks he might be Australia's only messenger of the Prince of Darkness himself. Alfie runs a website called www.depravity.com.au where he posts his own and links to others' dark content. Obviously, the Prince of Darkness isn't interested in sunshine, daisies and cat videos, so Alfie posts a lot of dark content, including content depicting violent criminal activity, gratuitous violence and sexually explicit material. Alfie doesn't restrict access to his site at all. This is Betty. Like Alfie, Betty also lives in Australia. Unlike Alfie, Betty is a massive fan of funny cat videos. She accidentally stumbled on depravity.com.au and is appalled at some of the content on the site. She's concerned that unsuspecting Australians, including children, might find the site too and be exposed to some of Alfie's horrible explicit content. Betty wants something to be done about this, and the sooner the better. But what can Betty do? Apart from furiously tweet, of course. Surely, she thinks, internet content is subject to the same restrictions as other content, like TV shows and films. Well, Betty, internet content hosted in Australia is subject to a similar classification system as TV shows, films and games. However, unlike television shows, which are usually classified before distribution, internet content is classified after distribution through the complaints-based system contained in Schedule 7 of the Broadcasting Services Act of 1999. Schedule 7 applies to content and hosting services within Australian connection. For international content, Schedule 5 applies. In this example, we've got Alfie's site, which is hosted in Australia, so Schedule 7 applies. Under Clause 37, Betty can make a complaint to the Child E-Safety Commissioner that the content on Alfie's site may be potentially prohibited. Only Australian residents, companies carrying on business in Australia, or any of the Commonwealth or state or territory authorities can make a complaint to the Commissioner about potentially prohibited content. Clauses 20 and 21 define potentially prohibited content and prohibited content, as including content that might be refused classification or is X-rated, or content that isn't subject to a restricted access system and is R18+, or is MA15+, excluding text and still images or news and current affairs, or is MA15+ and provided by a premium mobile service. So back to Alfie. Let's say his site does contain content that is potentially prohibited. What then? Well, the Commissioner will ask the Australian Classifications Board to classify the content on Alfie's site against the National Classification Scheme. If any of the content on Alfie's site is refused classification or classified X, R18+, or MA15+, then it will be prohibited content per Clause 20. So Alfie's hosting prohibited content. What now? Well, the Commissioner can issue a number of notices if the Commissioner is satisfied that the content is prohibited or potentially prohibited and has an Australian connection. The first is a final takedown notice issued under Clause 47 to the hosting services provider of Alfie's site. As Alfie is linking to other sites with prohibited content, the Commissioner can, under Clause 62, issue Alfie with a link deletion notice. Say Alfie is providing a live stream to satanic goings-on in his site. Then the Commissioner can, under Clause 56, issue Alfie with a service cessation notice. Each of these notices require the receiver to either take down the content if the content has been refused classification or is X-rated, or take down the content or put it behind a restricted access system if it is R18+ or MA15+. So there you go, Betty. Alfie's prohibited content won't be available anymore. And Alfie, if you want to put your Prince of Darkness content online, you might want to make sure it's not too explicit and put it behind a restricted access system.